5 seconds to go. Start. It is submitted that the testimony of the said witness falls in the category of wholly unreliable witness, and as such the conviction on the basis of the testimony of such a witness could not be sustainable. Mr. Nagamuttu further submits that on the basis of the same evidence testimony, the learned trial court had acquitted 6 accused while convicting and sentencing the other 5. Mr. Nagamuttu further submits that there is also a doubt as to whether the FIR in the present case is a real FIR or not. It is further submitted that delayed FIR would create a doubt about the trustworthiness of the prosecution case. Ms. Ankita Chaudhary, learned DAG, on the contrary, submitted that the learned trial court as well as the High Court have rightly relied on the testimony of Amol Singh PW6. It is submitted that merely because a minor contradiction, inconsistency cropped up in the evidence of the witness, it cannot be a ground to disbelieve the truthfulness of the testimony of such a witness. It is submitted that the maximum falsus in uno falsus in omnibus is not accepted in India. She therefore submits that grain has to be separated from the chaff to find out the truth from the testimony of the witness. From the material placed on record, it would reveal that the conviction of the present appellants is based basically on the testimony of Amol Singh PW6. A corroboration is sought from the medical evidence in the nature of post-mortem report. It will be apposite to refer to the following observations of this court in its celebrated judgment. Hence, in our opinion, it is a sound and well established rule of law that the court is concerned with the quality and not with the quantity of the evidence necessary for proving or disproving a fact. Generally speaking, oral testimony in this context may be classified into 3 categories, namely wholly reliable, wholly unreliable, neither wholly reliable nor wholly unreliable. In the first category of proof, the court should have no difficulty in coming to its conclusion. Either way, it may convict or may acquit on the testimony of a single witness if it is found to be above reproach or suspicion of interestedness, incompetence or subornation. In the second category, the court equally has no difficulty in coming to its conclusion. It is in the third category of cases that the court has to be circumspect and has to look for corroboration in material particulars by reliable testimony, direct or circumstantial. It could thus be seen that this court has found that witnesses are of 3 types, viz. Wholly reliable, wholly unreliable, and neither wholly reliable nor wholly unreliable. When the witness is wholly reliable, the court should not have any difficulty inasmuch as conviction or acquittal could be based on the testimony of such single witness. Equally, if the court finds that the witness is wholly unreliable, there would be no difficulty inasmuch as neither conviction nor acquittal can be based on the testimony of such witness. Stop.